It is my pleasure and my honor to kick us off on the first of our 8-session series on the topic of civil commitment. My name is Sarah Kopelovich. I'm a clinical psychologist with forensic expertise who works in the Center for Mental Health Policy and the Law at the University of Washington in the Department of Psychiatry and Behavioral Sciences. And I also co-direct the Spirit Center, which is another center within our department. I'm excited to be moderating this first session on civil commitment 101, overview of history and current practices. And I'll be introducing our speaker, Shadoe Jones, in just a moment. I first just want to take a moment to welcome you all and to get us started with a few informational slides. So first, I want to acknowledge the land and the labor that have gone into this presentation. The University of Washington, based in Seattle, acknowledges the Coast Salish peoples of this land, the land that touches the shared waters of all tribes and bands within the Squamish, Tulalip, and Muckleshoot nations. May we always honor their spirit and heritage while working for justice in these communities. To identify the stewards of your lands, I encourage you to visit this native-land.ca. This is an incredible website that actually has an interactive map where you can look at territories and languages across the world. We also acknowledge the unaddressed legacy of stolen labor and slavery. We recognize our debt to exploited workers, both past and present. This legacy remains and is a current reality for many today. For those of you who are just getting familiar with the Center for Mental Health Policy and the Law, we are housed within the University of Washington's Department of Psychiatry and Behavioral Sciences in the UW School of Medicine. Our center fosters integrative scholarship to advance empirical knowledge, training, and practice in forensic mental health. Our mission is to address the most urgent issues arising at the interface of mental health and the law, to help justice-involved people with mental illness lead full and productive lives. We've organized our center around 3 pillars of excellence: education and training, research and policy, and service. These pillars are intended to facilitate interdisciplinary collaboration and innovation by removing barriers between researchers, policymakers, educators, and clinicians. And what better example of just that than a webinar like today's that involves so many of these professionals and community members. So this is, just as a reminder, this is part of a 8-session series on the topic of civil commitment that the CMHPL is hosting. As you can see, the series brings together an array of experts, including clinicians, legal professionals, educators, policymakers, and individuals with lived experience. Each of the first 7 talks will feature an aspect of civil commitment that's within the purview of that expert. And then all the speakers will convene on June 10th for a moderated panel discussion. So if you have not registered for other sessions in this series, you will see a link on the slide that will get pushed into the chat as well, where you can register for any of the subsequent webinars or the panel discussion. In terms of the recordings, we will make the recording and presentation slides available on our website a week after each webinar, and we will email attendees with the link. Certificates of attendance will be available for attendees who have indicated interest, and you'll receive an email from cmhpl@uw.edu with additional details. If you would like, there is continuing education available for those who are attending the live session, but not for those who are attending the recording. And so for those who would like to pursue the CME, you should have already received an email from cmhpl@uw.edu if you're UW faculty or staff with instructions. For non-UW learners, we'll be tracking attendance via Zoom, so please make sure that your name is updated if you do want to pursue CME. Today's speaker, Shadoe Jones, has no financial relationships with an ineligible company relevant to this presentation. I have a relevant financial relationship to disclose with Listen, which doesn't factor into this presentation. None of the other planners have relevant financial relationships to disclose, and all relevant financial relationships have been mitigated. All right, a few final logistics before I introduce our speaker for today. First, the opinions expressed within this webinar are the views of the speaker and don't reflect any official position of the CMHPL or the University of Washington. No official support or endorsement of the opinions described in this presentation is intended or should be inferred. For those who would like to pursue closed captioning, just go to the toolbar on your Zoom panel and you'll see the show captions icon. You can click on that. We encourage you to submit questions using the Q&A function on Zoom. That's also on your lower toolbar. And we will do our best to answer those questions live with our speaker. If we don't get to them, we will be banking those questions and we may pose them to a speaker on a subsequent webinar or during the panel discussion in June. All right, so with that, I'm going to go ahead and introduce our esteemed speaker for today. Shadoe Jones advises on key policy considerations, collaborates with legislative partners, and provides legal counsel to advocate for the improvement of state and federal laws and systems of care to benefit individuals with severe mental illness with the Treatment Advocacy Center. Previously, Jones served as a criminal defense attorney in Arizona, and she received her Juris Doctor from the Sandra Day O'Connor School of Law and a bachelor's degree in criminal justice and sociology from the University of Delaware. Civil commitment is Shadoe's bread and butter, so we are in the right hands for our talk today. So I will turn things over to you.
Thank you all for coming today. Before I joined TAC, I was a criminal defense attorney for individuals with severe mental illness. And in that role, I saw firsthand how many of my clients needed intensive care long before being charged with crimes. And their actions were often driven by untreated mental illness, yet they only received care after arrest, which shifted the focus from recovery to fitness for prosecution. And many of my clients face homelessness, violence, and victimization, consequences of untreated or undertreated mental illness. And research shows that they often go untreated for an average of over a year, which leads to brain damage and worsened outcomes. So many of them cannot access voluntary services due to the nature and severity of their symptoms. And so today I hope to provide some insights into the involuntary treatment system and how we can work together to improve it and use it to serve those that I described. So to make most of our time together, I'll highlight some key points while you review the slides at your own pace. And as Sarah mentioned, a copy of this presentation will be shared with you guys for review. And so today's objectives are to explore the history and current practices of civil commitment with a focus on Washington State. To achieve our objectives, we will explore a range of broad topics and we'll reserve time at the end for questions and answers. To help guide our discussion, I would like for you to take a moment to rate your current knowledge on a scale of 1 to 5, with 1 being none and 5 being expert on civil commitment. Thank you for taking a moment and letting me know your level of knowledge. That gives me an idea of how much to go in depth today on our overview and primer for the next sessions. I'm going to start our discussion with some civil commitment basics. So, voluntary treatment is always preferable. However, severe mental illness can impair the ability to make rational decisions or recognize one's own condition, making voluntary services inaccessible. So treatment can restore these individuals' autonomy, and court-ordered treatment is often the only accessible option when somebody with a psychotic condition is experiencing a symptom called anosognosia. Anosognosia, or lack of insight, is a neurological impairment that blocks self-awareness of an illness. And according to various research studies, it affects 57 to 98% of patients with schizophrenia spectrum disorders, which highlights the importance of involuntary treatment. Civil commitment is a non-punitive civil court process that makes medically necessary treatment accessible for people who are unable to recognize their illness or the connection between treatment and improved outcomes. Commitment standards are high to ensure that people who can make rational decisions about their healthcare are given the autonomy to do so. Civil commitment refers to various forms of involuntary treatment, and today we'll be focusing on inpatient and outpatient commitment, but I'll briefly mention the other forms. So civil commitment process typically begins with an emergency evaluation, or initial hold is another name for this, which can lead to inpatient commitment, which is a stay in a hospital that may last from a few weeks to several months, depending on severity of illness, state law, insurance, and resources. And all but 2 states have laws allowing for outpatient commitment, which is broadly known as assisted outpatient treatment, or AOT. In Washington State, AOT is still in its early stages, so the term may be a little unfamiliar, but we'll go into that more later. And it's important to note that civil commitment does not automatically mean a person will be medicated against their objection. A separate court order is often required for involuntary medication with a separate process. Conditional release is another option, and that's where a person is discharged to the community with conditions for treatment and case management. I want to take a moment to do a check-in question, and I would like for you guys to let me know what illness and system-related barriers prevent individuals with severe mental illness from voluntarily seeking treatment. Thank you for your responses. All those factors are relevant and can be barriers to treatment. For the illness-related factors, all 3 of those can be classified under the concept of anosognosia, which is thought to be the most common reason for people with SMI not consistently engaging in care. And the system-related factors can also be barriers to care engagement. So civil commitment is intended as a safeguard for individuals and community safety. And the government derives its authority to provide civil commitment from 2 broad powers: parents patriae, meaning parent of the country, and police powers. Parents patriae is the power that authorizes protection of children and incapacitated individuals, while police power authorizes criminal statutes and regulations related to public health, safety, and welfare. So in general, these authorities recognize our society's choice to use legal powers to support vulnerable people and protect the public at large. Having covered some civil commitment basics, I want us to explore how we got here and how we can leverage historical insights to inform our future. So first, I would like to give a brief overview of the time periods that we'll be talking about. And before the 19th century, the government focused primarily on community safety. So jails and poorhouses served as a place to house those with behaviors that were not widely understood to be medical conditions at that time. During the 19th century, there was a shift towards treatment that led to large asylums. And initially they were intended for care, but they became plagued by overcrowding, inadequate resources, lack of training, and abuse. So mid-20th century, deinstitutionalization aimed to transition care from these asylums to the communities, but unfortunately it lacked coordination and funding and contributed to today's ongoing care system challenges and efforts to improve outcomes. So we're going to explore these key historical shifts and their lasting impact. So civil commitment really emerged in the 19th century era of asylum. And that's when individuals with mental illnesses were confined to these large institutions that provided basic care. Commitment at this time was based on a diagnosis and a recommendation for treatment without any procedural safeguards. So states assumed responsibility for those who were incapacitated, and they presumed asylum patients incapable of making their own decisions. However, not everyone detained under these conditions needed institutionalization. The limited understanding of mental illness led to inconsistent care and at times harm, while abuse and overcrowding became common in many facilities. By 1890, every state had a public psychiatric hospital or asylum, but these institutions struggled to care for the sickest and poorest individuals, while private hospitals offered better care to the few who could afford it. The disparities between public and private mental health care continue to persist today. The mid-20th century brought significant change with the National Mental Health Act, the rise of antipsychotic medications, and growing awareness of the conditions in the asylums. So the National Mental Health Act created the National Advisory Mental Health Council and the National Institute for Mental Health. The development of novel antipsychotic medication offered help or hope that individuals could recover at home. And at the same time, the asylums their overcrowding reached a peak of nearly 560,000 patients. It was during this period that a report from the Joint Commission on Mental Health, highlighting the dire conditions in these facilities, caught the attention of President John F. Kennedy, whose sister had a severe disability. So in response to that report, Kennedy established a cabinet-level interagency committee to formulate an appropriate federal response. This committee's work, combined with public outcry, pushed the nation towards closing state hospitals and promoting outpatient care. But more than just these federal committees shaped the public opinion. So in 1946, Life magazine's expose, Bedlam, exposed the poor conditions in US mental hospitals. And then the book and film, One Flew Over the Cuckoo's Nest, depicted an institutionalized character who was not mentally ill. So that fueled public fear and reinforced the national opinion that the problem was with the institutions and not with the illness. So as asylums struggled and their operations cost soared, states began to recognize the financial burden of maintaining these facilities. And at the same time, civil rights movements were going on, prioritizing individual rights, autonomy, and further influencing mental health policy. This led up to the end of the asylum. So as state hospitals rushed to empty their wards, courts began defining legal standards for civil commitment to ensure evidence and due process. A landmark 1975 case set the precedent that individuals must be deemed dangerous to qualify for commitment, and that shifted the criteria from a medical one to a legal standard requiring an evidence of harm. This shift aligned with political pressures, and it left the most severely ill individuals to fend for themselves, but incapable of doing so. The services that were envisioned by President Kennedy in the Community Mental Health Act were unfortunately never fully realized. The limited funding often went towards broad services that were primarily benefiting those who were well enough to want help, keep track of their appointments, and pay their bills. Fast forward to 1999, and the pivotal Olmstead decision established the requirement to provide services in the least restrictive settings. This served as the foundation for our current system, which mandates this least restrictive care, but often delays intervention for the sickest individuals until their symptoms are severe enough to pose danger, at which point they require the most restrictive type of care to ensure safety. Deinstitutionalization had some unintended consequences, and with the standard of dangerousness, the medical system shifted to generally not intervening until a person is suicidal, actively violent, are grossly incapable of meeting their needs, because it's impractical to expect a crisis intervention to be timed perfectly to witness danger while preventing it. The result is tragedy and trans-institutionalization. Law enforcement officers are now the primary first responders to mental health emergencies, and jails and prisons have replaced psychiatric institutions on a scale of 10 to 1. But designing a civil commitment system to balance individual autonomy with personal, family, and societal safety requires a mix of constant and variable influences and creates challenges for anyone willing to reimagine the continuum of care. However, Washington State has a strategic planning project underway right now, so it'll be interesting to see how involuntary services fit within the system redesign. So the historical evolution of civil commitment highlights the ongoing need for improved access and quality to care. So we're going to talk about the current US system in general before we go into Washington State. So typically, involuntary care follows state-specific laws because there's no national standard for mental health care delivery. But there is a typical process across the states that begins with emergency custody for evaluation when there's evidence of danger or harm. And in practice, most individuals are discharged within hours or days, often without a stable care plan or follow-up. But if commitment paperwork is filed, the case goes to civil court, and the individual has a right to a hearing, representation, and to present evidence. The judge may order inpatient, or in some jurisdictions, outpatient commitment if a program is available, and if not, the person is discharged. It's important to note that medical decisions such as diagnosis, medication, and discharge planning are separate from the legal proceedings, but definitely influence the outcome of care. So all states can provide involuntary care when an individual is deemed a danger to themselves or others. But the criteria for assessing dangerousness is what varies across the states, and interpretations can be quite subjective. So a common subjective interpretation of an under-resourced system is to apply the term of imminence to the standard of danger. Imminence means in the moment. So for example, if a person threatens suicide with a knife, but is disarmed by police, the imminent danger is removed. So in places that apply an imminent standard, whether formally through statute or informally through practice, that person may not meet criteria for intervention despite posing a very recent serious risk. This approach limits care to crises, and that leads to an over-reliance on costly, restrictive environments like hospitals or jails, which can hinder recovery. And it also creates delays in access to care and perpetuates a cycle of crisis that is both inefficient and harmful. So this is the typical dangerousness criteria. And while treatment access laws generally incorporate some or all of this listed criteria to determine dangerousness, a comprehensive treatment statute alone does not guarantee comprehensive access or implementation. We're going to review some information regarding the states, and TAC has developed a grading system that we use to analyze state laws. So the data that I'm about to present, we review this periodically for updates, and the last date of review will be on the slide. But if you have any questions about this data specifically, you can feel free to email me afterwards, and I will be happy to provide you more information. So as I stated, most variation between the states is to deal with assessing dangerousness. A lot of that variation comes and assessing dangerousness towards oneself. So overt suicidality is always part of the standard, but a person can pose a threat to life by failing to eat or drink or take medication for serious conditions such as heart disease, diabetes, an infection. Tax helpline often hears about people who are deeply paranoid about food, water, or medicine being poisonous. And that's a delusion that was very common amongst my clients. Avoidance across time of these materials and important needs can render that person gravely disabled by some state standards, but not by all. So some states now include psychiatric deterioration in their criteria, and that is to allow intervention before harm occurs. So, for instance, if someone has a history of arrest and hospitalizations for acting on their belief that standing naked and freezing temperatures is required for health and safety, psychiatric deterioration standards can enable timely intervention to prevent further decline. Unlike a strict dangerous standard, which often requires evidence of harm and relies on this dubious assumption that intervention can be perfectly timed to prevent a tragic outcome just before it otherwise would take place. So currently 30 states, including Washington State, have adopted standards for psychiatric deterioration, but there are some nuances that we'll discuss later. Grave disability is generally understood to mean a failure to meet basic needs. Currently, 4 jurisdictions do not explicitly include this criteria, but all others do. So all states allow for the temporary custody of individuals in psychiatric crises for emergency evaluation. But these laws vary mainly in 2 areas: the duration of this custody and who can initiate the proceedings. So most states permit emergency custody for up to 48 to 72 hours. With Washington State recently extended theirs from 72 to up to 120. And like in most states, Washington does use that term up to, and that allows providers to discharge patients sooner for any reason, or for many reasons, rather. So currently, as far as who can initiate these proceedings, 27 states allow any responsible adult, while 23 restrict this to professionals only. Washington restricts this to professionals, but includes an exception for a delayed petition by adults through Joel's Law, which we'll discuss later. Today, inpatient psychiatric beds are part of the continuum for individuals who are in acute crises and those with complex needs, or those who are involved in the criminal justice system who have been placed in treatment either for competency restoration or not guilty for reason of insanity. Inpatient civil commitment is very important amongst the continuum of care, and who can access that through petition is any responsible adult in 31 states, professionals only in 15, and then the remaining states permit petitions from professionals and specified individuals, which is typically guardians or legal custodians. Washington State restricts petitions to professionals only. The length of hospitalization varies across the states, and it varies within the state as well. It ranges from a few weeks to several months. And Washington is one of the few states that requires multiple court petitions for extended hospitalization. We'll discuss that in more detail in a little bit, but it has a tiered system. So outpatient commitment refers to court-ordered treatment in the community, which is the civil court holding the client and the treatment team accountable for adherence to a treatment plan. Successful outcomes through these programs rely on outreach where providers locate and support clients who miss appointments or struggle to maintain stability. The most common name for this process is assisted outpatient treatment, or AOT, and it's typically ordered upon discharge from inpatient care for individuals who function well enough to attend outpatient services but have a history of noncompliance or non-adherence because they cannot understand that they are ill or that treatment supports their quality of life. 32 states permit any responsible adult to petition for access to this program. 13 states, including Washington State, restrict it to professionals, and 4 states allow both professionals and specified individuals to petition. While every state except Massachusetts and Connecticut has AOT laws, many are still working on effective implementation. So expanding the use of AOT is a policy priority of TACs and other organizations that advocate for wider use of this evidence-based practice. And to note, with all 3 of these emergency, inpatient, outpatient petitions, for those who are citizens or non-professionals petitioning for those services, some states do require a professional certification to be included in that petition. I want to take a moment for another check-in question. I would like for you to answer why community mental health programs have not been able to adequately replace the institutions to meet the needs of people with severe mental illness. Thank you for your responses. So everyone's correct. These are all reasons why community mental health programs have not been able to replace institutions for those with severe mental illness. So now let's take a look at current laws and practices in Washington State. And as we do, keep in mind that what's written in statute doesn't always match what happens in practice. And across the state, there are going to be variations in both quality and access to care. We're going to use a case scenario shared by Tax Helpline team to illustrate some of the points. And of course, all the names and identifiable information in that case scenario have been changed, but the substantive facts are the same. For context, here are some Washington statistics. So just over 200,000 individuals with SMI or severe mental illness live in Washington State, with fewer than half receiving treatment each year. Individuals with SMI are 2 times more likely to be incarcerated than to be in a state hospital bed in Washington State. And Washington has fewer than 14 inpatient psychiatric beds per 100,000 people, which is well below the 50 beds per 100,000 needed for standard of care. This bed shortage leads to negative outcomes, but other trends have been concerning as well. So when there is a bed available, the most common 2 reasons that hospitals in Washington deny care are aggressive behaviors and inability to meet basic needs, such as hygiene. So since dangerousness and grave disability are criteria for involuntary care, people are denied care for the same reasons they are eligible for it. This creates a huge gap in the continuum of care and contributes to further criminalization, homelessness, violence, and preventable death. The Involuntary Treatment Act is the name of Washington Civil Commitment Statute. The ITA, since its adoption in 1973, its implementation has evolved through amendments, court rulings, investigations, and lawsuits, which have all reflected advancements in psychiatry, changing societal attitudes, and economic factors. And like most states, Washington's system is under-resourced. The ITA establishes criteria for the system's use in fulfilling its social responsibility to provide treatment to individuals who pose a danger or cannot protect themselves from harm. However, the state's healthcare authority delegates the interpretation of this criteria to local authorities, which lends to variability in how the law is applied across the state. So if you notice, Washington statute does include threats of harm to self, others, and property as part of criteria. So now I'm going to discuss the case scenarios. We're going to consider a Washington case scenario from Tax Helpline. A husband, we'll call him Bill, has been concerned for several years about his wife. We'll call her Sue. Sue is convinced that a foreign mafia is pursuing her, and she believes that the mafia has conspired with Bill to install listening devices throughout their home. As her delusions have escalated, she's destroyed most of the home's wiring, including smoke detectors. She is deeply afraid most of the time and attempted suicide by swallowing non-prescription medication, but fortunately threw it up in time to stop the process. She threatened herself with a knife in front of family, but when Bill requested an emergency evaluation, he was told that the property damage didn't count because it was Sue's house, and that the past suicide threats weren't imminent enough to warrant a response. Bill was told that the law requires an immediate threat of harm for intervention. But remember, when I mentioned that policy and practice sometimes impacts what happens more than what's written in statute, Bill later got different interpretations of the ITA from different sources. But despite clear signs of danger, responders determined that the criteria weren't met for Sue to be evaluated, and Sue stayed home while Bill waited for things to escalate so he could try again. And I mentioned earlier that Washington State does have a psychiatric deterioration standard. And in 2020, Washington passed a bill to adjust the standard under the ITA to account for a person's severe departure from safe behavior. And that's aiming to provide a means of intervention before an individual's illness leads to serious harm or death. Unfortunately, though, this standard has not been implemented because of the bed shortages Washington is facing. So whether Sue's destruction of her home and suicidal threats would meet the new standard isn't up for us to decide, but it is important to note that the law's language is not even applicable yet because of the delay in implementation. A unique aspect of Washington's system is the use of designated crisis responders, or DCRs, as gatekeepers for the involuntary treatment. So a designated crisis responder can place a person on an emergency hold, can request transport by ambulance or law enforcement if they find imminent harm or grave disability. If a DCR doesn't issue a hold, a person with knowledge of the situation has a second chance opportunity to initiate a hold by petitioning the court directly through Joel's Law. And Joel's Law is named after Joel Rauter, who was a young man who did not meet criteria for a hold before he was unfortunately killed by law enforcement who misunderstood his delusional behavior that involved a gun. Back to our case scenario, Bill filed a Joel's Law petition and also kept calling for a mobile crisis response while he waited to hear from the court on the petition. One call to the crisis responders did result in Sue's hospitalization, and it's unknown whether his Joel's Law petition would have changed the outcome. But it's troublesome that the mechanism for getting help for an emergent crisis elicits a slow motion process with complicated paperwork and inherent delay. So Joel's Law requires for the person with personal knowledge of the event to wait 48 hours before they can petition the court. But once they do petition the court, if it's upheld by the court, the same designated crisis responder system that failed to act on the initial report would it be called out to organize transportation to a facility for that individual. Based on family reporting, Joel's Law is inconsistently understood and inconsistently applied across the state. In Washington, once a person is placed on emergency hold, they have to be medically cleared before being evaluated for their psychiatric condition. The evaluation team has 24 hours and then either needs to discharge or petition a judge to issue an official hold that can last up to 120 hours for evaluation. Those 5 days exclude holidays and weekends. And in our case scenario, Sue was held for just under a week. I briefly mentioned this earlier, but Washington is one of the few states with stage durations for inpatient commitment. And each commitment stage requires a petition, a court hearing, and a court order. Only professionals can petition for the extended or renewed orders. So if a family member or legal custodian files a Joel's Law petition, if it is upheld and that individual is evaluated for 120 hours, it would be the treatment team who would need to petition for the initial commitment for 14 days. If that individual continues to meet criteria, the treatment team would have to petition again for the next stage of up to 90 days and then again for the renewal. This is where Sue from our scenario's hospitalization ended. The hospital staff did not petition for a longer hold, stating that although she was psychotic, she was not continuing to cause or threaten harm. Assisted outpatient treatment, or AOT, is still in its early implementation in Washington, but this graphic shows an overview of how the program has been designed. And TAC did some research recently, and we found out that programs in Pierce County are the oldest and most successful, with about 10 current clients. Counties in the north, central, and southwest regions of the state are managing a few cases, and King County did a pilot program a few years ago, and they're working to restart this program. A law passed in 2022 that gives Washington Superior Courts the authority to issue these orders, and they can last for up to 18 months. The petitions for assisted outpatient treatment, though, have to be professionals who can be a designated crisis responder, the hospital, clinical providers, mental health practitioners, or jail release planners. One challenge to the system, though, is that those professionals who petition must testify to pursue the AOT order, and that creates a disincentive in a system that is troubled by understaffing. So the problem of too few providers also creates a barrier by making it difficult for agencies to invest in AOT. But if an AOT program has been pursued and the treatment team is working with a client who decompensates, they must refer the situation to the same designated crisis responder system responsible for all ITA admissions. So the judge on the case through AOT cannot directly order the client to inpatient care, and that's created some frustration within the courts, which they must also choose to participate in AOT. So enthusiasm for AOT in Washington has been mixed, and there's room for more education about AOT, what it means and how it can save lives and the resources that it can save. So TAC's AOT implementation team has offered to support this work as Washington is working through implementing it across the state. Here's a little more detail about the Washington bed shortage that I've mentioned a few times, and this highlights a troubling trend, which is that more individuals receive inpatient care due to criminal charges than because they meet criteria for civil commitment. So you'll see under 2023, the state beds count. Civil beds are those who are placed inpatient through the civil commitment process. Forensic is a term used for beds that are reserved for individuals undergoing competency restoration or involved in not guilty by reason of insanity cases. Many of you are likely familiar with the class action lawsuit in Washington, referred to as True Blood, which led the state to prioritize forensic beds over civil commitment beds. This lawsuit led to hefty fines for the state 4 mentally ill criminal defendants who were waiting too long in jail for evaluations or competency restoration. And this lawsuit is not unique to Washington. These lawsuits have been happening across the US, but Washington is unique in its rapid response in opening new forensic beds. One interesting outcome of the True Blood settlement is the Forensic Navigator program, which offers an out-of-custody competency restoration option, so individuals can be restored out in the community. And there's room for that program to be integrated with AOT to improve outcomes. And as I mentioned, Washington is not unique in this bed shortage. It mirrors challenges that are going on nationwide. But Washington has been very quick in responding and being in line with the True Blood settlement. But like other states, Washington still lacks sufficient civil commitment beds and has inadequate outpatient services, which can prevent safe hospital discharges, which contributes to bed blockages. Because if there is no effective community-based care to release somebody to, new beds fail to open for other patients. There's still work to be done, and these problems aren't new. 30 years ago, former U.S. Secretary of Health, Education, and Welfare, Joseph Califino, noted that we got into much of the current mess by acting on the best of intentions without foreseeing the worst of the unintended effects. In 2021, the Washington State Hospital Association echoed this, warning that fixes to the ongoing gaps and shortages, quote, come with a high risk of unintended consequences, not just for Washington's inpatient behavioral health system, but for the healthcare delivery system overall. Moving forward requires a clear understanding of the system, where it works and where it doesn't. Take Sue, for example. The tax helpline team is in contact with her family, and Sue remains undiagnosed and unaware of her mental illness. Bill anticipates she'll meet criteria for another hospitalization soon and might qualify for AOT. The family hopes Sue will receive the right care before something tragic happens, before someone gets hurt or she gets arrested. No one wishes for an overcrowded asylum to help Sue, but they do wish for a more sensible, effective way to help her recover and reclaim the life that was disrupted by her severe yet treatable mental illness. We'll take a question break now. If you could take a moment and answer, what problems are inherent in Washington State's involuntary treatment system? Those are all things that could be worked on in the Washington system. If you would like to know or take a deeper look into anything that I talked about today, I have linked some additional TAC informational resources and pages for you in the PowerPoint that will be shared. I'm also available by email, but I hope today's presentation gave you an overview of civil commitment in broad terms, where we are currently across the US and where Washington is comparatively. And thank you for your time today. I think we're going to take some time for question and answers.
I just want to say thank you. This was a lot of information to cover in a short amount of time. And so I just want to remind everyone that we are reconvening for the next several months, once a month and through June, which is our panel discussion, where we are re-inviting all of our speakers throughout the series back for a moderated discussion. Many of the questions, there was an incredible amount of activity in our Q&A. So thank you to everybody who put a question or comment into the Q&A. I do want to assure you, given the amount of time we have left, that if we don't have we won't have time to get to all of them, but we will be posing those either to the relevant speaker in a future webinar or during our panel discussion, or in some cases both. So thank you all for the fabulous questions. Shadoe, your expertise is, and the value that I think you bring to this series is that you really have this 30,000-foot view because of your role at the Treatment Advocacy Center of all what is happening around the country. Are you seeing other states that are setting a gold standard for effective use of involuntary commitment or implementation of involuntary commitment laws? And what can we learn from those states?
So there's no single gold standard, because each state has its own needs and flaws and good about their laws. But effective systems do share some common elements. So states can learn the importance of access to care, and that's a broad range of access to care. So a broad range of mental health services, from emergency care to long-term community support and quality of care. So there needs to be delivery of high standard, evidence-based, and culturally competent care. And then I kind of spoke to it with a broad range, but a continuum of care and coordination. I think one of the good changes and good gold standards that we're seeing across the states now is promotion of coordination of care between different providers. I think it lends to a better outcome for everyone if the entire treatment team is in communication. But it's about building out a robust system that has these common core elements, but how those elements look for each state is going to vary.
Yeah, I mean, I could not agree more with the importance of care, a true continuum of care and coordination across the nodes of that continuum. And that is something that I will be addressing in my talk in the series, and what's happening in Washington State to try to advance this mission of care coordination. There were also a number of questions that came up in the Q&A that were really wanting to dive deeper into the specifics of Washington State law, and how the laws pertain to not just folks that are evidencing psychiatric deterioration or risk, but also substance abuse. And so I invite folks back to the January 7th webinar, where we'll really be diving deep into our state laws and how those laws are being applied. So I just want to thank you again, Shadoe, and I want to just give a prelude to our next webinar. Our next webinar is actually in the series, is actually going to be our grand rounds for the Department of Psychiatry. It's going to be sponsored by the Center for Mental Health Policy and Law as part of our Bruce Gage Lecture in Forensic Mental Health series that will take place December 13th at noon Pacific time, and will be delivered by Dr. Philip Candelas, who will be talking about the ethics of civil commitment. So please join us for that. And thank you for everybody who stuck around until the bitter end of this this phenomenal webinar. Not to prime you all, but we would like your feedback. And Selena is pushing out a very brief survey. It should take you just a few seconds to complete. And there is space in that survey to enter any comments that you may have for our team. Thank you again for taking the time to fill that out. So that does bring us right up until the end. I do want to thank our resident expert today, Shadoe Jones, for giving us this comprehensive overview of civil commitment.
Thank you so much for having me.